Greetings, class. What I'm going to do now is to cover an introduction to Chapter 9, which is the Introduction to Contract Law and Contract Theory. We'll be talking about contracts for the next several chapters, so I wanted to give you a good foundation to continue to review this chapter, both for the exam, which is coming up tomorrow, but also to review for the next discussion assignment that you will have. So what's a contract? A contract is a legally enforceable agreement. And I have a memory device, a mnemonic device, a calf. A calf, of course, is a baby cow. The elements are, 1, an agreement. That's the A. 2, consideration. That's the C. A, assent. And that refers to the genuine agreement to the terms of the contract. L is legal subject matter, and the F is formalities. And we'll go through these, and we actually cover these during the course of all the contracts chapters, but I know for me sometimes it helps me to have something to hold on to as I'm trying to remember the different components. So we have a calf. Now, Chapter 9 talks about classifying contracts using different terms, and we're going to go through some of that. We won't go through all in detail, but the first distinction that's made in the chapter is a distinction between informal contracts, and here informal contracts are represented by these jeans that are pretty informal. They have holes in the legs. And then formal contracts, which I have here a formal dress. And the idea is that when you look at contracts, one of the things the law looks at is whether the law requires a whole lot of formality in making the contract. And the answer is generally no. The law does not require a whole lot of formality. Now, it does require elements of a contract to be present. But once those elements are present, it doesn't have to be a long formal contract that you may be used to seeing when you're, for example, signing a real estate contract or when you're signing a contract to purchase a car from a dealership. They have long contracts. The law doesn't require that formality. In fact, most of the time, an oral contract is a valid contract. So now what I'm going to do is to ask you a couple of questions. And I'll just ask you to, as we go through these, to think about the questions. Don't just, listen to me and then listen to me read the question and then move on. I'd like you to read the question, take out a sheet of paper, jot down what you think is the answer, and then use this as a study guide, because if you miss some of these questions and you want to go back in the chapter and look at that information again. So the first question is, which of the following is not a required element of a contract? And the list includes legality, consideration, legal capacity, and a writing. The second review question is, true or false, a unilateral contract involves one party to a contract. A bilateral contract involves two parties. And then the third question is, true or false, oral contracts cannot be enforced. So what I'd like you to do is to pause the video, think about these questions, and then come back. Okay, so hopefully you did take a few minutes to just answer the questions on your own. You can see the answers here. First, which of the following is not a required element of a contract? A writing. And if you remember when I gave you the mnemonic device, a calf, I did not mention writing at all. Oral contracts are enforceable, although there are exceptions to that rule that we'll look at later in the contracts chapters. You start out with the assumption that if someone has an oral contract, it's still a valid contract. The second question, which is actually marked 3 on these answers, I apologize. True or false, a unilateral contract involves one party to a contract. A bilateral contract involves two parties. And that is false. You saw if you missed this one, you saw unilateral and said, okay, that's 1, bilateral, that's 2, But remember, in order to have a contract, you have to have two parties, right? Two parties who agree to the terms. Instead, unilateral contract involves one promise in exchange for an act. A bilateral contract involves an exchange of promises. So that's why this one's false. And then the third question, which again on the handout on this slide is marked 4. True or false, oral contracts cannot be enforced. That's false. I mentioned already the general rule is that oral contracts are enforceable, and the exceptions are when they are not enforceable. Now, on to a few more review questions. True or false, there's no difference between a contract that is void and one that is voidable. And then the second question, distinguish how express, implied in fact, and implied in law or quasi-contracts are created. Now this one is not just true, false, multiple choice. This one, the second question requires that you jot down an answer. So again, pause the video and write out your answers to these questions. If you need to look at the book, you can do that. I would recommend that you try to answer them first. Hopefully you've already read the chapter, and then go back and you can check your answer. So again, I hope that you have taken the time to pause the video and answer these questions. Here are the answers now. For question 1, there's no difference between a contract that is void and one that is voidable. False, 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 and false. There is a big difference between a contract that is void and a contract that is voidable. There's a big difference. Go back to the book, look at it, make sure you understand it, memorize the definitions if you have to, because as you're reading, if you don't know the difference between these two, you can get incredibly confused. Now, the second question was more of a short answer question. Distinguish how express, implied in fact, and implied in law contracts are created. And here are the answers I've given you. An express contract is created either by a written or oral agreement of the parties on the specific terms, and it's expressed by the parties' words. So if you think about a real estate contract, or you think about an automobile contract, that's an express contract that's created by the words of the parties, and those words are usually in writing, and sometimes a very long, detailed writing. But that's an example of express. Note that express can be oral. It's just that the terms of the contract are spelled out between the parties. An implied in fact contract is a contract that's created by the conduct of the parties. So sometimes it's a combination of words and conduct, but it's not just words. And so an example of an implied in fact contract is if you go to the vending machine to buy, let's say you buy a sandwich in a vending machine. Although I must admit, I would not buy a sandwich at a vending machine because they're not very good. But, and you can tell, I know that because I've done it before. But let's say you're buying a sandwich at the vending machine. You walk up to the machine and you don't talk to it, right? Not usually. Now maybe you talk to it because you've had experience with that machine before, and so you're telling it to listen to you. But your words don't create any part of the contract. What creates your part of the contract is when you put the money in and you push the button for the sandwich that you want. That's what creates the contract on your part, and then the machine dispenses whatever you requested, hopefully. But that's implied in fact because it's created by the conduct of the parties. You've created it, combined with the other party, put the machine there in place, put words on it to explain how much things would cost and what you could get. And so that's how the contract is created. It's not express because your conduct, your participation in the contract is by your conduct. And then the third one is an implied in fact, or implied in law or quasi-contract. This is not what they call a true contract. The law doesn't consider this a true contract because a true contract, the parties are agreeing to something, whether they agree by conduct or whether they agree by words. In the case of a quasi-contract, the law creates a contractual obligation between the parties, even though there is no contract. In fact, there's no quasi-contract if there is a contract. Or another way of stating it is, if you look at what the parties have done and said, and you find that there's a contract, it can't be a quasi-contract, because a quasi-contract only exists if the parties didn't agree. But because of the situation, the law created a contract to prevent unjust enrichment, to prevent someone from benefiting by the conduct of another person and just kind of snapping up a really good service or good. So it's not really a true contract. And for all of these terms, I want you to go back to the book and reread it, or some of you said that you went on Google and searched it. Now, if you go on Google and search, realize you have to look at what you're reading to see if the source is credible or not. Don't just because you saw it say that, oh, this must be believable. But sometimes you can get additional information to help explain something by doing a search on the internet. Now, there's a lot of terminology in Chapter 9. I'm not going to go through it. I made this nice Wordle, it's called, that lists a lot of these terms. What I want you to do is to go back to the book. There's a chart that defines, I think, all of these. And make sure that you understand. Really, you almost have to memorize these terms so that you recognize them in other contexts. So if you get a question, you already know, okay, if it says it's a void contract, I know what that means. So I'm not going through these terms, but just be sure you look them up. So how is the contract created? It's created by the agreement of the parties in words, conduct, combination of that. That's when a contract is. Remember, quasi-contract's not a true contract. So I wanted to leave by talking about Miller versus Stevens. You have the case in the book. I don't want to go through and revisit the case, but I did want to read some of the language in the case where the court talks about an implied contract. And what the court says is a contract is implied where the intention as to it is not manifested by direct or explicit words between the parties, but is to be gathered by implication or proper deduction from the conduct of the parties, language used or things done by them, or other pertinent circumstances attending the transaction. And so even if there's no express contract, there can be an implied contract. And that's from Miller versus Stevens. That's on page 292. And I've listed that on the slide. Okay, so that's it for the introduction. I will also give you a few other short kind of mini lectures so that you can have more of an overview of contract law.